Good afternoon and welcome to the webinar, which is part of our series of COVID-related webinars. I appreciate that we're all extremely time poor at the moment, but with homeschooling, working from home and various challenges that brings, and we're grateful for you taking the time to connect with us during this time of crisis. Here at Irwin Mitchell, we're trying to bring our clients, communities and colleagues together, and please do let us know if after this session you can think of any other ways that we can assist you during the pandemic and beyond. By way of introduction, I'm Elsa Anderson and I'm a solicitor in the Commercial Dispute Resolution team. My fellow panellist is Tom Payton, a partner in our Restructuring and Insolvency team. We'll have some time for questions at the end, so thank you to those that have already submitted them. If you'd like to ask any other questions, please submit them via the Q&A function on your screen, and we'll do our best to answer them at the end of the session. You can also submit questions to us after the event via events@irwinmitchell.com, and that email will be at the bottom of the slides at the end. Just to let you know, we'll be recording this virtual event and we can send you recordings out afterwards. I'll now pass over to Tom.
Thank you very much, Elsa. So yes, thank you very much for joining us today. I will be focusing today on directors' duties to consider in light of coronavirus, both in terms of in a solvent situation and an insolvent situation. And then following on from that, Elsa will be taking perhaps a step back and seeing how directors can avoid companies getting into that situation in the first place, even in the current predicament that we find ourselves in. So what are the directors' duties that there are to consider? Well, irrespective of coronavirus, there are statutory duties which all directors have to adhere to, and those are set out in the Companies Act 2006. That's irrespective of whether the company is in a poor financial position or not. When the company then is in a difficult financial position, which we'll go on to define in more detail, there are duties then which change in nature upon that insolvency situation. So what are those duties? Well, they're quite wide-ranging. Some are obvious, some are a little bit more discreet. So the first one, to act within the powers that are given to the directors by the company's constitution. Most companies that have been set up in the last 20 to 30 years have quite a wide constitution, and they generally give directors quite a wide ambit in terms of how they deal with their powers. But companies that were set up further back than that, they often have rather archaic articles of association which are more restrictive. Duty to promote the success of the company, that's a fairly obvious one, but it has to be borne in mind in the context often of group situations, where a director might be director of more than one company within that group, and they might all have different interests, or indeed a separate company which is maybe in competition or in some way not aligned to that company's interest. Further, a duty to exercise independent judgment, fairly straightforward in interpretation. A duty to exercise reasonable care, skill and diligence, again, and a duty to avoid conflicts of interest, which interlinks fairly obviously with independent judgment and success of the company, a particular issue in group situations. A duty not to accept benefits from third parties, and a duty to declare interests in proposed transactions or arrangements with the company. The obvious one being, for example, if a company was to sell assets to another company which one of the directors of the selling company is, say, a shareholder or a director in, and the other directors were not aware, there would be a need to declare that. So, to whom do the directors owe their duties? Well, in solvent situations, it's owed to the shareholders, i.e. the members, basically to do the right thing in terms of making profit and to keep the company on a good footing. However, when the company goes into an insolvent situation, that doesn't necessarily even mean that it's gone into a formal insolvency procedure, but it's actually in a financial distress situation. That duty flips and it's owed to creditors. So there are some obvious things around that in terms of where the duties of creditors and the duties of members might not be aligned. I'll come on to those in a second in terms of more detail, but in terms of the nature of this, it's when the company is on the verge of insolvency or actually insolvent. Insolvency is looked in through two different ways. Firstly, in terms of a simple balance sheet test, i.e. are the company's assets greater in value than the company's creditors. Particular care has to be given as to whether the assessment of those assets is done through rose-tinted spectacles or whether it's a more realistic assessment, and also the same with creditors, that every last creditor is taken into consideration, and also contingent creditors where they may not be asking for money now, but they may or likely to be asking for it around the corner. Further as well, paying debts as they fall due is the other test for insolvency. So the classic one is that a supplier provides a service, invoices, the payment is due within 30 days, and that the company receiving that benefit does not pay it within 30 days. If it's done that rather than it being an oversight, or it's disputed the underlying service or the debt, then that will be seen as evidence that it cannot pay its debts as they fall due. So some examples of breach of duties in insolvent situations. So this is where the directors owe their duty to the creditors, but they are either completely ignoring that duty, or they're mistakenly continuing to serve the interests of the members and shareholders instead. The first one would be making unlawful distributions to shareholders. So this is essentially when you have a dividend to shareholders and you have to have disputable reserves and profits to do that, the distribution is made and maybe as a dividend, and there was never any profit to do that. That's something that directors need to be particularly careful about, because often in owner-managed businesses where the director and the shareholder are the same person, the director might have been advised by their accountant to take their remuneration in carrying out their services for the company by way of dividends instead of salary, by way of a formal employment contract. Now, the reason that often happens is because it's more tax advantageous often to have the remuneration taken in that manner. The problem that the director has is that if at the end of the year, the dividends that have been taken really as interim dividends on account of the final dividend being called, if there's not been sufficient profits or distributable reserves at the end of the year to do that, then they have a problem, and they would have to pay that back if the company goes into a insolvency procedure, because the liquidator will be able to call on that. Similarly, some directors will often take their remuneration where they're not a shareholder. They'll take it, again for tax reasons, as a director's loan. So the fiction is that during the year, money is loaned to the director in tranches each month, which is roughly equivalent to what they would have had in a salary. And at the end of the year, the loan is written off, and there is a tax efficiency in that. However, the obvious problem with that, if the company goes into a liquidation scenario or administration or a formal insolvency, is that that loan will be called on. So directors have to be careful about whether they place emphasis on the tax advantages of taking remuneration in certain ways, rather than just going for simple salary. Now, that causes then issues for other directors who may not have been drawing any remuneration, because if they have allowed those other directors to take, say, a director's loan, or to receive unlawful distributions as a shareholder, then they too will be on the hook, unfortunately, for breach of their duty and allowing that to happen in a future insolvency of the company. Another example is preferring certain creditors. So the classic scenario is where a company will, say, have various suppliers that are providing services, but it cannot afford to pay them all. In some situations, the business and the directors may feel that they can continue the business, and this is just a tough trading month, but that they will need to make payments to certain of those creditors to keep the key supplies coming in. If they can trade out then the other end and everything's fine, then that's possibly been a very savvy strategy. However, it can be either abused or misinterpreted where the company goes into liquidation, because if those certain creditors were preferred in a way that wasn't realistically, objectively to help the business continue, then the directors themselves can be pursued by the liquidator for that, for allowing that to happen. The same happens with transactions in an undervalue. So that is essentially where a company transfers one of its assets for less than market consideration. If that was to happen on the director's watch, the director can potentially be sued, as well as the company or entity that received that transfer of an asset. The granting of security are the same. Directors have to be careful with that as to whether that is in the best interest of creditors. So the classic one is giving an unsecured creditor, say a trade supplier, security over the company's assets for a historical debt. Directors have to be really careful about that. It's a little bit different where the security is given for a future debt that's not yet been incurred, but particular caution has to be given for these historical debts being secured. And then lastly as well, particular care in group situations, the classic thing being in the good times, companies in a group situation may well decide to put assets of the top company or one of the middle companies into a property holding company, maybe near the bottom of the group. And that may be, that all washes round and everything's fine in the grand scheme of things because it's all accounted for. But if it happens in the run up to an insolvency or during an insolvency situation, that is not necessarily in the best interest of that company's particular creditors. So the director may also be find themselves liable in that situation. So real care has to be given. What are the consequences for directors who breach their duties? Well, going back to the beginning of this presentation, I mentioned that directors can breach their duties in a solvent situation where the company is fine. So in that situation, they owe their duties to the members. So unless it's perhaps an SME where it's the directors and the shareholders are one and the same and they know what the other's doing, if it's a larger business, or perhaps a business with silent shareholders where they're not really involved in the day-to-day affairs of the company, those shareholders may not be happy with the conduct of the directors, even if the company is in a financially sound position. And that director could be pursued for compensation, restoration of the company's property if they've transferred it to themselves, for example, and account for profits if they've caused damage in that respect, or rescission of contracts. In insolvent situations, it's slightly different. The same remedies exist, but they're actually easier for the liquidator to pursue when it goes into a insolvent process. So, for example, the costs that would be incurred by a company pursuing one of its directors when it's been solvent and it's not in liquidation or administration, but it's pursuing a director for a breach of duty, those costs would be very substantial, and the company would often also have a substantial adverse cost risk because the director would instruct their own solicitors potentially, and if the director wins in that action, then the company will be liable for those costs. However, a liquidator has a slightly different position, and this is something that directors have to be even more aware of, therefore, when they're dealing in this twilight zone, where either the company is definitely insolvent or it's potentially insolvent, because a liquidator can bring a much quicker process to seek compensation through breach of director's duties, and liquidators frequently are fairly used to and comfortable with bringing litigation, and they have various tools available to them, such as litigation funding and adverse cost insurance, which they can take out. So the next thing I'd like to just briefly touch on is wrongful trading. The reason this has become quite pertinent, as I'll come on to in a minute, is because the government have brought some measures in, and this has been the one that's grabbed a lot of headlines. So just to go over this, for those of you that aren't aware, wrongful trading is usually a claim that is brought by liquidators on the basis that between two separate points prior to the company going into liquidation, the company has worsened its position in terms of its balance sheet. The first point is looked at as when the liquidator argues that the director should have known that the company could not avoid insolvent liquidation. So let's say, for example, going back to the summer of 2019, there is evidence that maybe the director should have voluntarily put the company into liquidation because that was not avoidable. And let's say, for example, the director continued to trade the business, perhaps with rose-tinted spectacles, hoping things would improve. Perhaps comes around to this year now, and maybe the company goes into liquidation around about now. If the balance sheet of the company has substantially changed for the worse, wrongful trading claim would allow the liquidator to potentially sue the director for that worsening amount. However, there is a defence to this if the director can show they've taken every step to minimise potential loss to the company's creditors. So things around that, they can be all kinds of things in nature, but some of the things that have been brought in at the minute, for example, furloughing and minimising general exposure to rent and other creditors, those are the kind of steps that can be used in mitigation, but it's a very risky strategy to run. So in a liquidation, if a wrongful trading claim was normally brought, and the court found that the director had breached their duty in that respect and was liable to compensate the company, it's a financial remedy. So in other words, the director would have to pay a sum to the liquidator plus probably some adverse legal costs. The other thing that's often open to, well, not open to, but the directors are vulnerable to, is disqualification. So in a liquidation, essentially the liquidator, as well as potentially pursuing financial claims against third parties, whether they're the director or not, for any claims that may be available, the liquidator also has to send a report to the government on the conduct of the directors. If that report is critical of the directors, then there is a possibility that the government opens up an investigation, and that can lead to disqualification of the director. It can be wide-ranging from as little as 2 years up to 15 years, but it's obviously a very big impact for the director. Even if the director has little in the way of perhaps assets or finance to repay the liquidator on any claim, this type of claim, which is brought by the government, is not necessarily is not impacted by that at all. It's just something that the government may bring as a point of principle. So what changes have happened recently to the insolvency law, and what do they mean for directors at the minute? This is something I think a lot of directors are asking themselves, because we've heard of some announcements. We're not are we sure if this is coming to law, and how does this really change things, if at all? Some of the changes that have been announced are tools to help insolvency practitioners to help companies. So one of them is a rescue moratorium, so effectively a breathing space. That will be coming into action soon, as will a scheme of arrangement, which is for larger businesses and is a court-based restructuring tool. There's also rules that have come in to stop suppliers cancelling contracts with businesses when they go into an insolvency procedure such as administration. But the main thing I wanted to touch on was wrongful trading. A lot of people have been led to believe that the government has suspended wrongful trading, and that essentially directors are sort of operating in this in an area where they're not going to be held to account, and that, you know, if they take some financial and commercial risks, they're not going to have any comeback on them if the company does go into an insolvency procedure. Unfortunately, this is not the case. The suspension of wrongful trading is really only part, as you'll have seen already, it's only part of the potential claims that a liquidator can bring. So, for example, if a director was to transfer assets out to a company other than the company he's director of that has the assets, that would potentially be pursuable by a future liquidator if it wasn't for full market value, as would preferring creditors. Some of those types of claims do overlap with wrongful trading, but some of them they still would be pursuable in due course. So where this really leads to is that directors do really need to be careful in the way they conduct themselves. The government is really keen to encourage businesses to not throw the towel in unnecessarily too early. If we can come out of lockdown and businesses can trade out in a manner which looks after all the creditors, whether that's through paying them in full or through some kind of arrangement. But ultimately, if businesses do go into an insolvency procedure, the government has not waved a magic wand which has got rid of all that personal liability. So practically, what should directors do at the minute? Well, we could talk in a lot of detail about furloughing and all those measures, but to focus in on some more, I suppose, basic practical points, the directors need to consider the interests of the company's creditors. They need to be thinking about this on every decision they make, particularly where assets are transferred, money is paid out, any creditors are preferred, any remuneration is paid to as well to directors, etc. Directors need to be careful about approving the declaration of dividends. So even if the director is not going to receive the dividend themselves, if the shareholder is different, they need to be very careful about approving a shareholder dividend, because it, as well as the shareholder potentially becoming liable in due course, they could too for approving that decision. The directors need to be careful about not allowing transactions that are undervalued to occur or creditors to be preferred, and also to avoid entering into contracts which could be deemed to be a transaction defrauding creditors in due course. For example, if a director on behalf of the company enters into any contract or the taking of a deposit in the knowledge that that will not be fulfilled in due course. Practically speaking, that is really difficult because it is a huge chunk of the economy at the minute, which in terms of businesses, they'll be going through this thought process, and it is really hard because even the government cannot look into a crystal ball and know what is going on at the minute. The next bit I'd like to touch on briefly as well, because this has been in the news, is how to deal with statutory demands and winding up petitions. So again, a lot of people will be aware of these, but just to go on over this very briefly, winding up petitions are basically court proceedings that are brought by a creditor against a company that owes that creditor money, and they take as little as 6 weeks from start to finish. And if at the end the debt has not been repaid, then generally speaking, unless that debt is disputed, that company will go into liquidation. A statutory demand in a corporate context is a demand that's made formally and usually served on the directors or at the registered office, which demands payment of a debt. And although a statutory demand does not have to be used before a winding up petition, it often is, as it's a very formal way rather than a simple letter of demanding payment. So what's happening at the minute? Well, around about late March, the government announced that for landlords, it was going to prevent them issuing winding up petitions against their tenants if those tenants were corporates themselves. So everyone, I think, assumed that there would be some legislation announced a little while afterwards that would stop landlords bringing petitions in those situations, but probably not really affect the rest of the economy as a whole. So other creditors, if they're owed money, say for trade, supplies or whatever, they'd still be able to use that. Actually, what's happened is the government has announced a bill in the last 2 weeks, which goes much further, and it says it's not just landlords that will not be able to do that. It is all creditors who were going to pursue a company under a statutory demand or winding up petition. Interestingly, though, it does not affect individual people being pursued in the same way by way of a bankruptcy petition or a statutory demand, which may have been an oversight by the government. So anyway, what does this mean? Well, you're unlikely to see statutory demands or winding up petitions until the 1st of July 2020 at the earliest, because the current ban, it goes up to the end of June. This might be extended though. So whether you are a business that is owed money and you have been historically used, maybe through a credit controller, winding up petitions or statutory demands as an effective tool, or if you are worried that your own business is going to be pursued in the same way, for the minute there is a breathing space. However, this is going to change. After the 30th of June, unless it is extended, there is a potential cliff edge. Statutory demands and winding up petitions will be back, and that's both for debt that's been incurred in July and onwards, and also debt which is occurring at the minute. So businesses need to be really careful that they do not assume that they've sort of got a blank slate now, and that when after the 30th of June that everything goes back to normal again. It's going to be really difficult, because effectively, if they haven't been paying those debts now because they can't afford to, then come July they're going to have to find post-lockdown income to pay both future outgoings and historical outgoings as well. There's going to be a lot of businesses in that situation, and what we would stress is that not to assume one thing or another in terms of whether that's terminal or whether everything's going to be fine and then they can muddle through. The best thing is to speak to an insolvency lawyer or an insolvency practitioner to obtain advice early on. So my advice in that situation would be not to ignore creditors, to engage and seek payment holidays and agreements, and consider more formal options that may be available, such as CVAs, even if there's maybe a possibility of trading through. The implications of a winding up petition, which there may be a flurry of these after June, even if the debt can be paid, this should not be taken lightly. Between the petition being issued at court and the court hearing, which is usually 6 weeks later, the petition is usually advertised in a gazette, and that usually causes the bank account to be frozen, which can then really scupper the business, even if it was going to trade out of it okay before that. It can also affect the credit rating of the director personally, in terms of their ability to obtain finance with future companies with which they're a director. And when the company goes into liquidation, then that is terminal. All employment contracts are terminated upon compulsory liquidation, and there will be an investigation into the director's conduct. So it's something to really not take lightly and to avoid if it is feasible to. So now I've dealt with that, I'm going to hand over back to my colleague Elsa, because what we're conscious of is that although some businesses may find themselves on the precipice fairly soon, there'll be a lot of businesses thinking that they don't want to go anywhere near there, and what practically can they do so they're not even having to get into that kind of situation and to manage things. So over to you, Elsa.
Thanks, Tom. Obviously, we're aware that you're firefighting at the moment, so we're here to support you. We don't want you to panic. On that basis, we're going to focus on some practical ways now to minimise risks to directors of pandemic hit companies and share some tricks of the trade in terms of warning signs to look out for in relation to boardroom and shareholder disputes, as well as ways to resolve them. So firstly, you need to have realistic financial plans, current and forecasted, and reviewed regularly. Check debt arrangements and companies' abilities to meet scheduled repayments. When seeking to fulfil your director's duties, don't forget to comply with the health protection, coronavirus restriction regulations and government guidance on safety. Be mindful of the new bill that Tom mentioned, the Corporate Insolvency and Governance Bill, and what it's likely to mean in practice. Also consider other government guidance, for example on contractual disputes, where they're asking us to act more collaboratively and reasonably during the crisis. Though, of course, guidance is precisely that, guidance. As ever, it will be a careful balancing act for you to decide how to proceed. Take professional advice as appropriate and be able to show that you've acted in accordance with it. Inviting legal advisors to attend meetings where appropriate can provide assistance. Even the act of taking advice can help to evidence that you've sought to comply with your duties. Hold regular board meetings and record the minutes accurately whilst respecting social distancing. The new bill, if enacted, will help with this in terms of practicalities, timings, and logistics. Record the decisions that you are making and be able to explain them. Remember that these may be scrutinised at a future date. Record approaches to investors, stakeholder interaction and consent. Again, these may be scrutinised, and always declare potential conflicts of interest and ensure you enforce policies on abstaining from voting in cases of conflict, keeping records. Again, this is something that may be scrutinised at a later date. Check your insurance policies. Do you have adequate director and officer insurance? If not, consider obtaining it as it can cover the costs of claims made against directors by shareholders, investors, employees, regulators and third parties. Also check, if you haven't already done so, that whether or not you have relevant epidemic, pandemic or business interruption insurance. In addition, legal expense insurance cover is something that you may wish to obtain if you haven't already done so. Check what your policies cover and what you anticipated them to. If they don't cover what you expected them to, why not? Talk to your broker, and if you don't get an adequate answer, talk to a professional advisor. Communicate with your fellow directors and shareholders. Avoid surprises. Circulating briefing notes before board meetings is a way of successfully delivering decisions in a controlled manner when there's a lot on your plates. Experienced directors will often test the water on potentially thorny issues outside of the boardroom so that decision making can run more smoothly as well. Communicate with your customers. Monitor debt and credit arrangements, solvency and the demand. Communicate with your supply chain. Review payment terms and whether these can be varied, bearing in mind that the new bill, if enacted as currently drafted, will prevent termination of supply agreements on grounds of insolvency. Also communicate with lenders and auditors. Be transparent. Can you restructure payments or relax covenant testing? These things could all provide your business with important breathing space during the crisis. Consider your disclosure and reporting obligations too, and if listed, make arrangements for your AGM. Again, the bill provides you with some assistance in relation to this. Also check your contracts. Can you comply and continue to do so? What do your force majeure and illegality clauses say? Ensure that you comply with covenants wherever possible and explore options going forward if you're in a potential default situation. Check what your personal exposure is in relation to guarantees, and also contingency plan. Perhaps now more than ever, we must admit that the situation can change and could worsen. Consider government financial assistance, the availability of which will vary dependent on the nature of your business, but may be of great help. And consider using mortgage payment holidays, rent payment holidays, business rates holidays and furlough payments for employees. Although be alive to the fact that there may be repayment requirements associated with that in the long term. In terms of disputes between directors, there's a number of areas where classically issues can arise. The typical sorts of areas that cause concern include strategy and business direction, financial issues and of course potential insolvency, personal relationship breakdowns and power struggles, conflicts of interest, concern as to whether the board is satisfying its legal responsibilities, and the service contracts and levels of remuneration. A petition in relation to unfair prejudice under section 994 of the Companies Act is an example of when things can and do go wrong. Unfair prejudice arises when the affairs of a company have or will be conducted in a way that's unfairly prejudicial to the member, either generally or one part of the membership, including at least the petitioner. They often involve allegations where the majority shareholders have or are acting in a way that unfairly prejudices the interests of the minority shareholders. In terms of relief, the court has a very wide-ranging powers to regulate the affairs of the company, but most commonly the court would order that the majority shareholders buy the minority shareholder out. Another action in the name of the company, a derivative action against the directors. Derivative actions permit a minority shareholder as representative of all of the other shareholders to institute proceedings on behalf of the company. They can be brought in respect of wrongs committed against the company that, for whatever reason, the company is unwilling to address. These types of disputes, derivative actions and unfair prejudice claims can be hugely disruptive to businesses, and they can be very expensive. We recommend seeking early advice if such a dispute is on the horizon. But how can you spot when a dispute is on the horizon? There's a number of things that we would suggest doing when you're concerned about issues arising that may lead to serious disputes. We'd suggest that you keep an eye out in relation to directors and shareholders for a number of telltale signs that a dispute might be on the way. These kind of signs would include criticising the performance of other directors and shareholders, strongly disagreeing with the company's strategy or direction, taking an adversarial approach in correspondence and at meetings, or conversely unusual silences, changes in the method or tone of communications, when you start seeing the use of legalese or long emails that may well be setting the scene for a claim. Another example would be someone complaining about being excluded from decisions or meetings, purporting to speak on behalf of a group of directors or shareholders, the calling for board or members meetings to fit in around them at short notice, or requesting unusual documents or accounting information. Changes in levels of attendance and email use may also be an indication that there's a risk of a dispute. Importantly, spikes in data use could indicate data harvesting, and there would be real concerns in those circumstances that confidential information or customer details were being collected inappropriately. Similarly, proposals about restructures that are outside the norm, even in the current environment, should always be considered carefully, as well as the motives behind them. But how do you resolve a dispute when it arises? Communicate and document. A way forward can often be found so that you can go back to focusing on the business. Review the relevant articles of association, shareholders agreement and service agreements. Well-drafted documents may well provide a solution, or at least a process for resolution, such as mediation. Consider roles held by relevant directors. Are they also an employee or shareholder, and how will the dispute impact on the business in that respect? Consider the issues and any underlying motives, as well as the relevant parties' duties to the company and the extent to which they're being complied with. Can a way forward be found? If appropriate, explore whether the other party could be persuaded to resign in return for a severance package. Consider the balance of shareholder power. A director's or shareholders' resolution could be passed to remove a director. If there's no provision in the articles and a severance package is declined or inappropriate, removal with shareholder approval can be considered and may need to be explored. If the dispute relates to a performance issue or dishonesty, follow the correct procedures. Document all decisions and remember that emails and texts may need to be disclosed to the other party if litigation follows. Importantly, always consider your alternative dispute resolution options. Without prejudice, negotiations can help resolve the matter at an early stage. Similarly, mediation, which is incredibly popular, has a positive success rate of around about 75% in matters settling on or shortly after mediation. Arbitration could be used if the contract provided for it between the parties or if the parties agreed to use it. An expert in that field would be able to consider the matter and make a decision. Whilst arbitration is private, it can be quite adversarial, but a bonus side of it is that if you have cross-jurisdictional businesses, it does obtain international support with over 130 countries, ensuring that that decision would be enforceable. Similarly, the arbitrator has broadly the same powers and duties as a judge, and the award is enforceable by the court as if it were a judgment. Another option to explore when a dispute arises would be expert determination. That's where the parties agree to refer specific disputes or differences to a neutral third-party expert to decide. The parties can also choose their own timescales and the scope of the determination. The expert will then decide the dispute, which can be quick, cost-efficient and confidential without the right of an appeal. Another option that's popularly used in relation to construction contracts is adjudication. However, it does generally tend to be used solely by that sector. So I'll move on to another alternative, which would be early neutral evaluation, a process whereby an independent evaluator, usually a judge, looks at the merits of each party's case and then gives a reasoned evaluation. That opinion is non-binding and they won't play any further part in the negotiation, but it can really help focus a party's minds on the respective merits of either side and can facilitate a settlement on that basis. However you manage to achieve resolution, whether or not it involves seeking the assistance of the court, it's important to remember that if a decision involves an exit, you've got to consider the applicable restrictive covenants and confidentiality obligations that may be coming into play and the likelihood and consequences of any of those breaches and the potential damage that it could do to the company. In addition, you also need to consider the impact of any share sale or purchase that may be necessary and whether the business will remain viable. To the extent that it won't, liquidation may need to be considered as necessary, and at all times we'd recommend that you work closely with your legal team in relation to these issues. Another point that I know is a source of real concern is how you're going to be controlling costs of any disputes, particularly against the backdrop of COVID. And obviously, I want to take the opportunity to explain that we recognise that one size doesn't fit all and that controlling costs is really important to your business. Dependent on the matter, we can offer a range of funding options that can help you and get you the advice that you need flexibly. You can contact us and we're always happy to discuss what options may be available. Some of the key ones are obviously on the slide now. Hourly rates. These are the traditional measure of a lawyer's costs and they can be simple and clear in relevant cases, made certain by estimates, phase of work and cash flow. We can also offer capped and fixed fee options. These can be agreed for each phase of work on your behalf based on the level of work likely to be required for each phase. There's other alternatives such as discounted conditional fee agreements, which it would involve a lower hourly rate or fixed amount being invoiced on a monthly basis. But on a successful conclusion of the claim, the balance of the legal fees would potentially be payable by an opponent. Conditional fee agreements would involve there being no fee being charged unless you were successful. However, there may well be an uplift in the event of success. ATE and BTE insurance. In terms of after the event insurance, this is a useful opportunity to enable clients to basically hedge the risk of a potential liability to pay an opponent's costs in a claim if unsuccessful. Before the event insurance, I've already mentioned legal expense insurance. It can cover the legal costs of a claim, and we'd always urge clients to check whether they have the benefit of such policies at the outset of a matter. There's also options in relation to third-party funding, whereby a third party, as it sounds, would be able to fund your case in return for a share of the proceeds in the event that you were successful. Damages-based agreements, quite similar, but you'd agree to pay a percentage of sums recovered in a claim to your legal advisors. Or in the alternative, there could be the classic retainer on a periodic, such as monthly basis, that's scoped to fit in with your needs. Which of these options might be appropriate will depend on the nature of the dispute and the matter in question, but we're always happy to discuss them with you. So, in terms of a summary of what I've covered, we just always encourage you to communicate. It's absolutely key. Many complaints and claims arise from a failure to properly and effectively communicate. Document. It's vital to retain an audit trail of documents demonstrating how and why decisions have been made. Courts are persuaded by documents, and claims can live or die based on the strength of the physical and written evidence. Remember to consider the alternatives to proceedings and to take legal advice. If in any doubt, don't hesitate to contact your legal advisors, who'll be able to work with you to resolve problems as and when they arise. Now, at this point, obviously, there's an opportunity for us to address some of the questions that have come in, so thank you very much for sending them. I can see that we've got one asking if we could comment on the risks around the duty of care to employees in the context of COVID-19. Now, this is an area of focus for, I know, an awful lot of employers. Obviously, that goes without saying, and it's a very broad subject. So what I'd recommend is that you attend the session that we've got scheduled on the 4th, Thursday the 4th next week, where our colleagues that specialise in employment law are presenting on the issues that flow from this, and we can circulate details to the person that's asked this question shortly after the call, as well as sending some links to the material we've produced that will give you some useful guidance on practical steps you can take in this regard. I can see that we've also got a question saying that there's a fear about financial viability regarding a company. In circumstances where that's so, should they still continue to use a furlough scheme? I think, Tom, this is very much a question for you.
Yes. So furloughing itself is essentially cost neutral because the government is not asking for that to be repaid back. It's different to some of these other coronavirus type loans which are available, which will be repayable. So the furloughing itself is neutral. It's really what is happening at the time that employees are furloughed that is relevant to this, in terms of whether the directors themselves then have any potential liability because someone in the future is going to criticise them for their conduct. So the devil will be in the detail really as to what is going on with the company whilst those employees are being furloughed. Is the company essentially just being mothballed and literally not really paying anything out unless it's rent, which may also be perhaps negotiated down, and some business rates and the like? Or is it carrying on a skeleton staff? And then if employees are being furloughed, is that going to cause problems with the business? Are they going to fail, say if it was a manufacturer, for example, are they going to fail to meet orders that have already been made? Is that then going to cause loss to the company? So I would say it's not specific to furloughing, it's more the wider implications of not having employees there when you would normally have had them, and just day-to-day decisions which the directors are making, whether as a consequence of not having those employees there or just irrespective of that. So the furloughing aspect is probably a bit of a red herring. It's more the wider impact of it. So I think those are our 2 questions, unless there's any further ones anyone wants to put forwards. Okay, well, thank you everyone very much for joining us. It's been a pleasure to speak to you all, and I hope that was useful. As Elsa mentioned, we're here to help. Although some of the pieces I was explaining through at the beginning may be somewhat concerning, there is genuinely so much you can do if you take the right strategy at an early stage, and we are here to help you with that. So please do get in touch, and we are very, very keen to assist. Elsa, is there anything else from you?
I would just flag that obviously we've got a wealth of material available through our COVID hub, which is obviously on this slide here. And if you do have any further questions, we're happy to take things offline. So drop the events team at owenmitchell.com an email, or contact myself or Tom, and obviously we'll be happy to assist you in relation to any queries you may have. I think other than that, we can wrap up, and just thanks again for all your time.